UP's most outstanding law alumnus, Grand Cross of Rizal from the Order of the Knights of Rizal, Grand Lodge of Free and Accepted Masons of the Philippines, and Centennial Awardee in the field of law, given by the United Methodist Church on the occasion of its 100th anniversary. Despite the demands of his service to the nation, the Chief Justice remains actively involved in civic and church activities. He is a lay preacher of the United Methodist Church and the incumbent chair of the Administrative Council of the Puno Memorial United Methodist Church. That ends the faculty statement. Ladies and gentlemen, the eminent research fellow of the UP Law Center, a member of the Board of Regents of the University of the Philippines, a man who has shown the life of the law done in a grand manner, the former Chief Justice of the Republic of the Philippines, Reynato Puno.
UP President Emerlita R, the incoming UP President, the Honorable Alfredo Pascual, the Honorable Chairperson, and members of the UP Board of Regents. Then Marbik Leonen, the faculty of the UP College of Law, and let me greet especially my professor, Professor Laureta. My only other living professor is Professor Araceli Babiera. My fellow students of law, distinguished guests, especially my colleagues from government, the judiciary, past and present, led by Chief Justice Davide. Let me also greet my classmates from the College of Law, Class 62. Arguably the best class according to them. My friends and foes alike, ladies and gentlemen. Let me first thank the Board of Regents for this honor, confirming me an honorary doctorate degree. I don't feel comfortable delivering this lecture with the prefix doctor. I think more preferable is the appellation attorney. And perhaps better still, just a simple mister. After all, despite the dominance of ladies in the College of Law, the appellation Mr. is not yet out of fashion. I remember the time when President Carlos P. Romulo was granted another of his many honorary doctorate degrees. After the conferral, he was asked how he felt. And General Romulo said, with so many honorary degrees, I feel like a thermometer. But the problem he said is that I cannot even predict the political temperature in the Philippines. Thank you, Dean Leonen, for the generous introduction. In the last few decades, we have witnessed the birth of many democratic states. Statistics tell us that in 1914, with the disintegration of the Ottoman and Austro-Hungarian empires, there were only 55 honest to goodness states. The number jumped to 59 in 1919, to 69 in 1950, and to 90 in 1960. When the Cold War ended, the number of democratic states skyrocketed to an unprecedented height. After the independence of East Timor in 2007, their total number became 192. Some of these democratic states are now classified as failed states. In the case of the Philippines, some scholars have started to cast a doubting eye on our capacity to comply with the essential requirements of democracy. As early as 2003, they warned against what they call as our incubus of failure. They noted our accumulating democratic deficits. The observation is far from flattering, considering our checkered history of fighting for freedom and our elongated experience as a democratic nation. If we look at Asia's pantheon of ideas, we will find that Jose Rizal, Marcelo del Pilar, and other Filipinos espoused the ideals of democracy ahead of their cerebral counterparts, Mahatma Gandhi included. Indeed, social scientists regard pre-Spanish Philippines as one of Asia's early hatching grounds of natural rights, where the embryo of human dignity was nurtured even by its indigenous people. It is therefore no happenstance that in Asia we were among, if not the first, to constitutionalize the basic rights of man, rights that were to define democracy. A blast from the past will refresh us. In November 1897, Aguinaldo declared our independence from Spain at Biak na Bato and adopted a constitution whose principal features were lifted from Cuba. In a month's time, however, the Pact of Biak na Bato was signed, and pursuant to its terms, Aguinaldo agreed to surrender, got exiled in Hong Kong in exchange for amnesty, an indemnity of 1.7 million pesos, and the promise of rosy reforms. Thus, our first written constitution came to an end, even before we could savor our freedoms thereunder. As fate dictated, the United States and Spain came to war, and Aguinaldo and company were caught in the middle. Lured by a false sense, Aguinaldo fought side by side with the Americans against Spain. With the defeat of Spain looming as a certainty, Aguinaldo repaired to Cavite on June 12, 1898, and boldly read the document entitled Act of the Proclamation of Independence of the Filipino People, which ruptured every relationship between the Philippines and Spain. At the foot of the proclamation, it was curiously stated, witnessed by the Supreme Judge of the universe and protected by the mighty and humane North American nation. The new Philippine flag was unfurled and the newly minted national anthem was played. Aguinaldo's dream that the mighty and humane North American nation will recognize Philippine independence quickly metamorphosed to a nightmare. The United States defeated Spain and declared its sovereignty over the Philippines. Thence on, all efforts of Aguinaldo to preserve the Philippine Republic went down the drain. But to his credit, Aguinaldo did one great act of significance to the development of constitutionalism in our country. He convened the Malolos Congress that drafted a new constitution patterned after the constitutions of Costa Rica, Guatemala, Mexico, Belgium, France, and Brazil. It was principally prepared by Felipe Calderon with the sage advice of Cayetano Arellano. The Malolos Constitution was promulgated by Aguinaldo on January 21, 1899. UP historian Professor Teodoro Agoncillo hailed the Malolos Constitution as a great monument to the capacity of the Filipino people to rule themselves in a democratic way. It is worth noting that under the Malolos Constitution, the Assembly was made more powerful than either the executive or the judiciary. Calderon explained why they tilted the balance of power in favor of the Assembly. They were afraid, he said, that if the executive branch became powerful, then the ignorant soldiers who were for Aguinaldo would dominate the government. What prescience! Next, we orbited around the sun of sovereignty of the United States. And we have to undergo the whitening of our brown democracy. President McKinley formed the first Philippine Commission to study how a civil government would be established in a war-ravaged country. In his report, chairman of the commission stated that the Filipino people wanted above all, quote, a guarantee of those fundamental human rights which Americans hold to be the natural and inalienable birthright of the individual, but which under Spanish domination in the Philippines had been shamefully invaded and ruthlessly trampled upon. And so, guided by this pious wish, President McKinley issued on April 7, 1900, his instruction to the Commission that the civil government to be erected in the Philippines must be based on certain, quote, inviolable rules, by which he meant the Bill of Rights of the U.S. Constitution. Hence, the Philippine Bill of 1902, which temporarily provided for the administration of a civil government in the Philippines, carried these inviolable rules. Likewise, the Philippine Autonomy Act of 1916, or the Jones Law, which called, among others, for an autonomous government for the Filipinos, contained these inviolable rules or the guarantees of the U.S. Bill of Rights. In 1934, the Philippine Independence Law, or the Tidings-McDuffie Law, was enacted. It guaranteed independence to the Philippines and authorized the drafting of a new constitution for the Filipinos. Two sine qua non conditions were imposed by the United States. First, the government to be established must be Republican in character. And second, it should contain a Bill of Rights. The delegates to the 1935 Constitutional Convention were elected, and they chose the eminent Claro Emerito as president. They drafted a constitution that heavily borrowed democratic precepts from the U.S. Constitution. The resulting constitution was signed on February 19, 1935, approved by President Roosevelt on March 23, 1935, and ratified by a majority of the Filipino people on May 14, 1935. It served as our fundamental law, even after the U.S. granted our independence on July 4, 1946. Notably, it contained an ordinance which granted U.S. citizens equal rights as the Filipinos in the disposition, exploitation, development, and utilization of our natural resources. This economic imposition lasted until July 3, 1974. Despite this economic imposition, the 1935 Constitution served us in good stead in rebuilding our country from the devastation of World War II. It catapulted us among the leader countries in Asia in the decades of the 50s and the 60s. In the 1970s, our constitutional journey took an undemocratic detour. Then President Ferdinand Marcos suspended the writ of habeas corpus and shortly thereafter proclaimed martial law, ostensibly to quell a communist rebellion and restore peace and order in the country. President Marcos used his extraordinary commander-in-chief powers, even while a constitutional convention under the leadership of former President Diosdado Macapagal was in progress revising our 1935 Constitution. President Marcos' exercise of emergency powers was upheld by the Supreme Court, and the 1973 Constitution came into effect under contentious circumstances. The 1973 Constitution totally reorganized government, validated all the martial law decrees of President Marcos, and allowed him to govern with unprecedented powers, including legislative powers. It took years to bring down the regime of President Marcos. One explanation for its long life was the Cold War between the United States and Russia. Both superpowers unblushingly patronized client countries, even if they were ruled by authoritarians who showed no compunction, butchering the rights of their people so long as they kept their loyalty to either country. And so the Cold War enabled all types and stripes of dictators to reign all over the world. In Europe, the Americas, Africa, and Asia, including the Philippines. In 1986, the regime of President Marcos came to an end. As is the usual case, it was cut down by a revolution of the people, miraculously a peaceful one. The revolution catapulted Corazon Aquino to the presidency. During its short transition, she governed by means of decrees under a freedom constitution. She, however, immediately appointed commissioners to draft a new constitution in lieu of our 1935 Constitution. The Constitutional Commission was headed by Cecilia Muñoz Palma, a retired justice of the Supreme Court. Its draft constitution was approved by the Commission on October 12, 1986, signed on October 19, 1986, and overwhelmingly ratified by the people on the plebiscite held on February 2, 1987. The 1987 Constitution established a more democratic government by, among others, expanding the range of human rights of our people, rebalancing the powers of government, and giving the sovereign people more power to govern directly through referendum, recall, and initiative. Given the age of the 1987 Constitution, the geopolitical changes going on within and without the country, the question is whether there is now a need to reconfigure the Constitution to make it more responsive to the interests of our people. To be sure, the world has radically changed since 1987. The Cold War has been replaced by the War on Terror, which is eroding some of our civil and political rights. Communism has collapsed, and the visible hand that guided its economy has been ousted by the invisible hand behind free enterprise. Capitalism has gained a cultic following and is pushing governments to let loose the regulation of private interests. Globalization is resulting in the rise of supra-regional arrangements, sapping the sovereignty of national states. Certainly, these are changes which were never foreseen by our Constitutional Commission. In the home front, we see the defacing of our democratic facade. We have witnessed through the years the overt attempts at coup d'etat by the military, its undemocratic role in regime changes, its unconstitutional coddling by leaders of government. We also saw the sickening deadlocks between the executive and the legislative, especially in instances when the latter exercise its power to investigate in aid of legislation to crush corruption in government. We saw the raw use or misuse of the political power of impeachment by Congress. We saw the overarching exercise of the power of judicial review, even on arguable political issues. We saw the proliferation of political dynasties despite their prohibition. We saw the tightening of the stranglehold of monopolies and oligopolies. We saw the continuing marginalization of the masses by an elite that believes there is a constitutional right to be selfish. In short, our declining democracy is not giving the people a responsive and responsible government. Unfortunately, due to impoverished public discussion, all attempts in the past to amend or revise the Constitution to strengthen our democracy have not taken off the ground. It is too tardy in the day to dissect the overt and covert political reasons for these failures. But it is never too late to restart efforts to save our Constitution from irrelevance, strengthen our democracy, and enable government to meet the felt necessities of our time. There is reason to believe that now is the perfect time to rekindle this thought, for we have just elected a new president and inaugurated a new government. There is hardly any doubt about the pristine intention of our president to make our democracy work for our people. And it is our duty to help him succeed. I have been in government in all its branches for about 40 years. And with no exception, I say that our elected officials early on their term wanted to succeed in office and leave a legacy to our people. A lot of them failed, for their good intentions were devoid by a system of government that has been overtaken by time and corrupted by unscrupulous people. The big question is, as the prophets would ask, how do we get out of the belly of the whale? My task is merely to provoke debate on the necessity of amending our 1987 Constitution, change some of its dinosaur ideas, improve its institutional mechanisms, all with the end in view of strengthening our democracy and our constitutionalism. We need not change the Constitution from root to branches, but merely diminish its defects. But we need a modified Constitution to guide our leaders, for we cannot allow our leaders to govern us by clairvoyance. Let us not be hogtied. Let us not be hobbled by orthodoxies, for the first rule in the search for solutions to any problem is to be uncertain of the certain. Let me therefore pinpoint some areas of concern which are shared by others watching our difficult journey to democracy. First, our representative system of government leaves much to be desired. Because more than 100 years after exercising our right to suffrage, our elections are still not free, fair, and honest. This is a proposition that proves itself. It is futile to be blind to the fact that our elections are too expensive. They are often won by force or fraud. They are not issue-oriented, and they are more popularity contests where an unenlightened electorate usually trumps the enlightened. The result is a Congress which is the domain of the elites and dynasties, where our Muslim and indigenous brothers are underrepresented. We need to amend the Constitution to give more reality to the political equality of our people, where the vote of each is of equal value with the vote of others. We do not have a representative government, for significant sectors of our society are underrepresented or totally unrepresented in our policy-making institutions like the legislature. We have a synthetic democracy where the system allows our leaders to be elected not by the majority but by a mere minority. A hallmark of democracy is ruled by the representatives of the majority. And democratic majority includes not only the who is who, but also the who is not in society. Second, our democracy is not only tainted by political inequality, but also by a worsening social and economic inequality. A festering social and economic inequality is anti-democratic and anti-republicanism. For they breed people who lack the capacity to exercise effectively their civil and political rights. Democracy is about who makes decisions, and it cannot succeed in a setting where sovereignty resides in the many who are not free because they are uninformed. We need no evidence to prove these tearful facts. The eyeball evidence of the millions of Filipinos living below the poverty lines stares at us every day. Just follow your nose, and their stench will lead you to their hovels they call homes. At the very least, there is a need to amend our Constitution in order to make some of the basic socio-economic rights of the people, like the right to education and the right to health, demandable from the state in the same manner as our civil and political rights are demandable from the government. Constitution of countries like South Africa and India have treated these essential socio-economic rights as not merely directional in character but demandable from government, for they are considered as requirements of democracy. Lack of finances did not deter them, and their democracy became more vibrant. Unless we empower the many by improving their economic lot, we will continue to be ruled by a few who reject the ethics that enough is not enough. Third, the presidential system of government has resulted in gridlock, especially when the leaderships of the executive and legislative departments belong to different political parties. These gridlocks usually prejudice the common good and result in bad governance. We saw these gridlocks in the past, when executive officials refused to obey the summons of Congress, exercising the power of investigation in aid of legislation. These refusals shrunk the right of Congress in crafting laws, especially anti-corruption laws. These gridlocks will always stop the wheels of government from working and will not bring about a government that ought to work together for the good of the people. Again, there is need to amend the Constitution to delineate more clearly the demarcation line between executive privilege and the power of Congress to investigate in aid of legislation. Will the adoption of a parliamentary form of government eliminate these gridlocks in a presidential system of government? Will it result in a more responsive government because the parliament can be dissolved whenever the ruling party fails the people? Will it eliminate the threats of coup d'etats which are destabilizing to democracy? It is time to audit the merit of all these arguments. Fourth, we have a judiciary that is not completely shielded from partisan politics. No ifs and buts about it. Our judiciary lacks financial independence. A judiciary with a bent back and a begging bow is anathema to real democracy, for it will have no backbone to check the excesses of the other branches of government. A judiciary independent in paper, but a pauper in reality, is inimical to constitutionalism, for it makes it easy for unscrupulous politicians to whip judges to join the Hallelujah chorus. It is bad enough for the judiciary to be begging Congress every year for a decent budget. But it is worse walking to the DBM on bended knees for the release of an indecent budget. This has resulted in the tragedy of the High Court citing the DBM for contempt, and the greater tragedy of the executive thumbing its nose to the High Court despite the citation for contempt. This, to my mind, is unmitigated tragedy to the rule of law. We compound the problem when the judiciary, because of poverty, is driven to rely on the benevolence of foreign funders. Again, let us consider the suggestion that the Constitution should allow a certain irreducible percentage point of the budget for the judiciary and provide for its automatic release. Fifth, there is need to strengthen the judiciary by further depoliticizing appointments to the bench. Unless we can remove this virus of partisan politics molecule by molecule to disinfect appointments to our judiciary, our system of checks and balances will never fully work. again to the detriment of democracy. The Judicial and Bar Council can further diminish its vulnerability to partisan politics. 3 of its members, the Secretary of Justice, the representative of the Senate, and the representative of the House are carriers of this virus. Yet, they can be the swing votes on who to include in the short list of nominees to be submitted to the President for appointment to the Judiciary. Even the regular members of the JBC, representing the non-partisan stakeholders of our justice system, are not totally invulnerable to the arrows of partisan politics. They have an Achilles heel, which is the desire to be reappointed as members of the JBC. Again, these political vulnerabilities can be plugged by amending the Constitution and reviewing the composition of the JBC and the manner of appointment of its members. 6, there is need to relieve the High Court of its clogged docket and prevent its packing by the appointing authority. Justice to be of real value to democracy must not only be fair, but it must be fast. For if democracy is boring to the people, it is because of justice that travels in this slow lane. It must, above all, be credible. Given the unceasing influx of new cases, the High Court will continuously be burdened with clogged docket, and time constraint is the womb of decisions, poor in insight and short in foresight. The possibility of an incumbent president appointing all members of the High Court during his or her incumbency has come to pass, rightly or wrongly. It has raised quizzical eyebrows on the independence of the judiciary. But however it may be, no democracy can succeed without a judiciary enjoying the trust of the people. Ours is the task to produce a judiciary without these burdens. One way to declog its docket is to amend the Constitution to delimit the High Court jurisdiction only to significant cases. we must also be able to restrict its power so that it will not have the roving commission to review all acts of government on the ground of grave abuse of discretion, a term with an amorphous content. There is no democracy in the world where the judiciary has been empowered to be the policeman of government. Also, the Constitution should be amended to prevent its packing by any president and thus avoid the perception that courts are mere instruments and extensions of partisan politics. Again, we cannot afford a judiciary with a crack confidence. Seventh and lastly, when representative democracy is not fully functioning as in our case today, then the means by which the people themselves can exercise direct democracy should be improved. More than any of our constitutions, the 1987 Constitution placed greater stress on the democratic nature of our state more than the republican character of our government. The Declaration of Principles and State Policies of both the 1935 and 1973 constitutions simply state, and I quote, "The Philippines is a republican state." On the other hand, the 1987 Constitution went further as it states the Philippines is a democratic and republican state. It is not hard to understand why the 1987 Constitution described our state first as democratic and then secondly as republican. It is because our 1987 government was brought about by direct action of the people through what has become known as the peaceful people power revolution of 1986. Consequently, the 1987 Constitution as well as its implementing laws introduce novel mechanisms by which the people can exercise direct democracy together with the representatives they elected or despite of them in case they default in effectuating their will and protecting their interests during their governance. Thus, for the first time, under the 1987 Constitution, the people gave themselves the direct power to propose amendments to the Constitution through the process of initiative. Similarly, our laws now provide for the use of referendum by the people to resolve policy issues and the recall of some elected officials who perform below their expectations. Consistent with the democratic character of our state, the powers of the people to direct our government themselves should be expanded. There ought to be more liberal use of the referendum, a bigger coverage of our elected officials who can be recalled, and the liberalization of the process of initiative in amending our Constitution. The constraints of time shackle me from figuring other areas of concern. These additional areas are the systemic changes needed to address the unabated violations of human rights. Changes to uproot the deep-rooted corruption in the bureaucracy. Changes to make us globally competitive, and changes to provide a more flexible constitutional framework to accommodate the demands of insurgents and separatist groups, but without compromising our general interests. We elect our leaders, and it is our duty to provide them a constitutional framework of government where it is difficult for them to fail the people. I reject the argument that there is no urgency in amending the Constitution to arrest the decline of our democracy. We do not need a democracy in a stretcher. We cannot wait for our democracy to be in the ICU before calling the doctors. I started by saying I'm only peddling proposals of change in the hope of provoking debates. If I have done anything correct this afternoon, it is to choose the University of the Philippines as the marketplace of discussion of these proposals. The University of the Philippines is one venue where the irrelevant is not treated with irreverence. Where there is no idea that is considered as inciting to sedition. Where we are taught to doubt, and to doubt itself. Mabuhay ang UP! Mabuhay ang UP College of Law!
Thank you very much.